Despite the Supreme Court granting, vacating, and remanding review of a magazine ban case, a lower court continued its defiance by upholding the magazine ban, but at the same time in the same ruling, they struck down a narrow aspect of a state rifle ban. This decision is now up on appeal and oral arguments have now been set, so let's break down what is happening. Now, before we jump into this video, I want to thank one of our main supporters, which is Montana Knife Company. When Master Bladesmith Josh Smith launched the Montana Knife Company, he had one goal in mind, which was to create the ultimate do-it-all knife. He aimed to create something that was small, light, and good enough to, hunt with and also use for everyday carry. That knife ended up becoming the Blackfoot knife, and MKC, had that first ever model, and it's one of their best sellers. And it's one of the ones that sells out really fast even today. The Blackfoot knife created by MKC is never really on the shelves very, very long. They sell out really fast. So one of the things that I recommend if you wanted to pick up one of these knives for yourself is make sure you sign up for MKC's newsletter. That's one of the things I push you guys to do often. That's one of the best ways to get notified from MKC whenever they get restocked, when they have a new special drop, or when they do some sort of new release of knives. That is the way to get notified the fastest. So thank you again to MKC for sponsoring and supporting this channel. Now, as I mentioned in the intro, in this video, I'm going to be discussing two critical cases which challenge a state's ban on rifles and magazines. This magazine ban case was recently granted, vacated, and remanded back down to the district court for a new decision in light of what the Supreme Court said in their 6-3 decision, which was the Bruin case. Well, that district court recently issued a decision in two consolidated cases, which were ANJRPC versus Platkin, and then also Cheeseman versus Platkin. And in that ruling, the court really came to one of the more perplexing and kind of outrageous Second Amendment analysis and decisions, because the court found that the state's ban on the Colt AR-15 is unconstitutional and that it must be struck down. However, at the same time, they found that the magazine ban in the state was permissible and could be upheld. So the state could ban magazines that hold more than 10 rounds, but on the narrow aspect of an AR-15, a ban really specifically the Colt AR-15, they found that that was not permissible. However, all of this will now be reviewed by the Third Circuit en banc panel, who has set oral arguments in this case. Now, this case involves the state of New Jersey's ban on so-called assault weapons and their magazine bans as well. When it comes to the magazine ban that was passed back in 2018, New Jersey passed Assembly Bill 2761, which bans the possession of firearms magazines with the capacity to accept more than 10 rounds. This case was reviewed by a federal district court, and on review, they granted a motion for summary judgment in favor of the state of New Jersey. That was then appealed to the Third Circuit, and ANJRPC argued that the Third Circuit should not follow the precedent there because it was incorrect. They should not use the two-step approach because that is incorrect. And again, intermediate scrutiny did not apply to this case. However, the panel there rejected those arguments. And then a petition for en banc panel rehearing was also applied to for the Third Circuit, but in an 8-6 vote, that following month, the en banc panel denied review to this case. That then led this case to seek Supreme Court review back in 2022, but later it was then remanded back down to the lower court for a decision in light of what happened in Bruin, because Bruin came while this case was pending in front of the Supreme Court. And so the Supreme Court simply sent this back down to the district court, said, correct your decision because you used the two-step approach, you used intermediate scrutiny. That was struck down in Bruin. And again, they reaffirmed what the true 2A analysis actually is. So they said, go back, reevaluate the rifle ban, and rule in the correct way. Now, in the new decision, the district court showed how, essentially it was not going to faithfully apply Bruin. It was not going to use the proper analysis. Really, the judge believed that the Supreme Court got the analysis wrong in Bruin, and so he twisted the Bruin analysis to fit what he wanted to do in this case. In the ruling, the district court judge stated that it is hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table, when frequently radical individuals possess and use these same firearms for evil purposes. Despite that, the court stated it was bound to follow the ruling, but as a result, it issued kind of a hodgepodge decision protecting only limited sets of rifles, while at the same time finding that magazine bans were permissible and a state could just outright ban these types of items. When it came to rifles, he found that given the variety of firearms regulated by this law and the nuances that each individual firearm presents, the court's analysis of the firearms law here, the rifle ban, is limited to the firearm with which the court has been provided the most information, the AR-15. So one of the important things to note with this ruling is that the district court judge here decided to arbitrarily limit the review of this case to only AR-15s and ignore all the other semi-automatic rifles and shotguns and pistols that were also included and regulated under this law. Then when it came to the magazines in question, the judge did everything possible to twist Bruen with the goal of upholding this magazine ban. The judge found that magazines are arms within the meaning of the Second Amendment, which was very interesting because he recognized that there was precedent within the Third Circuit that said magazines are arms. He also found that these magazines are protected arms and they're in common use for lawful purposes. But then he deployed what is known as the more nuanced approach, based on new societal concerns, to find that magazine bans were still permissible, they're still constitutional, and a state can restrict these magazine items. So in the decision, the judge strikes down only the AR-15 part of the assault weapon ban. He avoided ruling on all the other firearms that are included in the law, and then he upheld the magazine restriction as well. Now, this horrible decision is being appealed to the Third Circuit panel here. The Third Circuit Court of Appeals is set to review this, and that's good because this is on a final merits. It's a final merits decision, and this would go a long way to potentially get a circuit split. Hopefully, we get a circuit split because if the Supreme Court does not want to grant review to some of the other cases that are pending in front of them, like Snope and Ocean State Tactical, you need a circuit split because maybe that is the last out for the Supreme Court to avoid this issue. Now, in the appeal, the plaintiffs argue that the court started off on the right foot, holding that New Jersey's ban on AR-15s, America's most common civilian rifle, is unconstitutional. But the court then arbitrarily cut plaintiffs' challenge to all the rifles, pistols, and shotguns that New Jersey outlaws as assault firearms down to just the most popular one. That is inexplicable. To be sure, plaintiffs sometimes used America's most popular civilian rifle as an exemplar of the kinds of firearms that the New Jersey law prohibits and encompasses. But that in no way negates the pages and pages of summary judgment briefing, expert declarations, and pleadings that the plaintiffs supplied addressing the full suite of firearms that this law and state bans. Meanwhile, as to magazines, the district court correctly held that the banned magazines are arms covered by the Second Amendment's plain text. It recognized, too, that they're in common use for lawful purposes, but things went south from there. In attempting to apply a nuanced version of an analogical reasoning, the court suddenly and without explanation held that state bans on possessing these arms was merely a restriction on how people may use them. So the plaintiffs point out to the Third Circuit how absurd this lower court decision actually was and how they twisted Bruen. Now, in response, New Jersey is trying to use the recent Ninth Circuit en banc panel decision in the California magazine ban case Duncan as support for why the lower court got this decision right. So the plaintiffs in this case have now taken it back to the Third Circuit, and they're asking for the Third Circuit to reverse what the lower court said. And here you have the state of New Jersey saying you should simply follow what the Ninth Circuit said and what other circuit courts have said after Bruen. The Third Circuit will now hear arguments on this issue of rifle bans and magazine bans after Bruen, and they will have to analyze it, in light of Bruen. That doesn't mean that they're going to come out the correct way, but they're simply going to review, did the lower court get this right? And they're set to review this, I believe, on June 6th. So very soon, within a month, the Third Circuit is going to be reviewing a critical rifle and magazine ban case. It might be a long shot, but the Third Circuit ruling in our favor would create a very critical circuit split, like I mentioned, that we need potentially to get the Supreme Court involved on this issue. One of the things right now that's pending in front of the Supreme Court is the Snope and Ocean State Tactical case. Those deal with rifle bans and magazine bans. Also, similar issues, similar rationales were issued by the lower courts. But one of the easy outs right now of the Supreme Court would be simply to say that there is no circuit split, which really there is no circuit split that would ever really develop because you would never have a conservative state like Texas pass a rifle ban and magazine ban, and then it would never get elevated to a circuit court like the Fifth Circuit that would find that those are unconstitutional. Just simply would never happen. So what you're seeing happen right now is you have liberal states passing these rifle bans and magazine bans. They get elevated to liberal circuit courts like the Ninth Circuit, and then they're upheld by those circuit courts because, of course, they're going to uphold those. They have a track record of being anti-gun, anti-Second Amendment. So you would never really see a circuit split develop. And one of the interesting things is you don't really need a circuit split on a very critical constitutional issue like this one. So again, a very important case dealing with a weird decision of a lower court, which held that a narrow aspect of the rifle ban was unconstitutional, but then at the same time twisted Bruen to uphold the magazine ban. So again, very important pill, very important oral argument that we're going to be seeing, how that develops. But as that develops, I will let you guys know. If you have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.